Matthew McCullough, Anderson.
Yes, Your Honor.
Good morning, Your Honor.
Good morning again. And we have Mr. Drury and Mr. Anderson present in the court, Mr. McCullough and Ms. Goldman appearing remotes. Mr. McCullough, Mr. Anderson, if you'd both raise your right hands, please. Swear the testimony in this case to be the truth, whole truth, and nothing but the truth. Yes.
I do.
Thank you. I'm just checking the docket entries, make sure that there hasn't been something submitted subsequent to my review of what had been, pardon me, previously submitted. So I reviewed everything that's been submitted by counsel and the affidavits, Ms. Goldman.
Yes, I'm sorry to interrupt, Your Honor. We filed supplemental papers on Friday, and I wanted to make sure that the court received those. Those were in response to a filing Thursday by the respondent.
I'm guessing I haven't. The last thing that came in were filings from Mr. Drury on the 16th, Thursday. So we don't have anything that came in on the 17th. So, but let's hold that thought. I understand that maybe somewhere in the email and mail we get on Friday, there may be other things there that are relevant to this case, but I assume they would be supportive of Mr. McCullough's position. I've spent a lot of time contemplating this case because it's kind of interesting, and it's, I guess, somewhat surprising to me that both parties are represented by counsel and somehow haven't seemed to come up with a resolution to this case, which, like I said, I find somewhat surprising. So I think as I think about that, and as I've looked at the various pieces of evidence that have been submitted in the statements of the parties, I'm going to share some of my initial views on this. And I guess the first thing I would say is that, Mr. Anderson, from what I'm reading and seeing, you're the neighbor that people don't want to have. I'm really, I wouldn't want to have you as a neighbor. So, and let me just describe why I say that. I say that because, you know, if I lived in a somewhat rural area and I had young children and somebody decides that because they enjoy it as sport, they are firing their weapon all the time on a regular and frequent basis, and they haven't come around to my house and say, here's what I'm doing, I like to do this, and I promise you it will be safe. And in fact, here, let me invite all the neighbors to come in and see exactly where I shoot so that they know that their families are not in danger from a stray bullet, from a ricochet. I have no sense that that occurred here. I have one family that's expressed significant concern, fear, probably. And it just is really surprising to me that somebody would use something that is so potentially lethal without going around and advising the neighbors and being friendly and say, come on in here, let's look. And oh, by the way, I'm building a firing range in my barn so that I don't have to fire outside, so that I can really make sure it's all safe. And I'll let you all know when that's completed. It strikes me as odd that somebody would do this. So that's the weapon stuff. And you have every right to fire on your property. You're in a zone you're in an area that's not zoned no shooting. So you have the right to do it. But just because you have the right, it's just surprising to me that you weren't a more courteous neighbor to just go around and say, hey, folks, I understand that this might be frightening, but you may have safety concerns, but come look and just show them. That might have changed everything. The lights and the sound. And what sticks out in my mind is one of the photos of your lights, which apparently are redirected towards your property. But it would, to me, looking at that photo at nighttime with those lights on, you'd have to have blackout shades to be able to get to sleep at night in the country. I mean, what kind of neighbor does that? Now you say you have security concerns. You're worried about people that have been breaking into the barn. Yeah, maybe. Or maybe you're upset that the McCulloughs have filed complaints about some of your actions. And frankly, at least 2 of their complaints have been sustained. So maybe you're mad that they're taking action against you, when frankly, in my opinion, that's exactly what they should be doing. If they observe something that occurs that's outside of what the law allows, they should report it to an agency and let the agency deal with it, which is exactly what they did. So it's just puzzling to me. And, the timing of your various actions here seems somewhat curious, as if, I recognize in the affidavit you're saying, no, I'm just doing this because I've had this ongoing security problem. But maybe not. Maybe you're doing it because you're mad at the McCulloughs for filing appeals or filing complaints. But frankly, my personal opinion, not being out there, that's what they should do. If you're doing something that's in violation of the Shoreline Act, they should let the people know. And you shouldn't take out your frustration with them, alerting them on them. You should go and try to talk to the protection agency and say, hey, you're misinterpreting the statute or the regulation, or propose a rewrite. That's the way you deal with it, not by taking it out on the people who notify them. They have every right to do that. So that's why I say, I'm reading this and I'm thinking, you are not a good neighbor, even though you may have the right to do some of this stuff, even though the decibel levels on the music isn't over the county limit. I mean, music being played all the time. Oh my gosh, that would be so annoying. I mean, if people moved in next door to you, where you live, and just decided, okay, I'm worried about somebody breaking into my house, so I'm going to play my music all the time, so it sounds like somebody's there. You understand, I know you do. So I'm just left with this strong feeling that you haven't been a very neighborly neighbor. So that's part of the context. The other context here I want to give is on the other side. I'm not sure, Mr. McCullough, that this is the correct process for you to address the concerns you have. I think there's an argument that Mr. Drury is probably going to make to me that this is not appropriate for an anti-harassment petition because to a large degree, Mr. Anderson's actions have to be interpreted by me as an attempt to harass and annoy. And he's going to make the case to me that no, he's innocently doing this because he has some history of break-ins that he's told us about in his affidavit, and he's trying to maintain the security of his property. And, he likes to fire his weapons, and he There's no restriction in the county ordinance against him firing his weapons. You know, there's nothing in the law that says he has to be a good neighbor. He doesn't have to come tell you that he's going to do this and that he's going to make you afraid to have your children outside or worried that they might be accidentally shot. So he's going to maintain that he has the right to do all the various things that he's done. You know, he redirected the lights. They don't shine directly at your property, even though they make your property at nighttime seem like a sun has risen on the neighbor's property. But, you know, he's going to argue he has the right to do that for security. Frankly, the better approach in my mind would be to file a nuisance action and perhaps seek an injunction and damages and those sorts of things. I'm not sure this is the type of case that's meant for a harassment action. So that's the context in which I'm looking at this. And since both parties have counsel, and I haven't seen any indication that counsel have attempted to negotiate something, I don't know how much. I don't know what has been presented as additional evidence since Friday. I suspect it's going to be probably more cumulative than it is anything else, because what I have is pretty thorough as far as the position of both parties. And, you know, can I think of other ways of dealing with this? Oh, heck yeah. First of all, what I suggested to Mr. Anderson, invite the neighbors onto the property. Say, hey, all of you who live adjoining to my property, I like to fire my weapons. Come on over. I'll just show you, you know, where it's going. I'll show you the mounds and the stumps and with the bullet holes in it where I'm shooting that don't put any of your property or your families at risk. And come on, look at my indoor range that I'm building. And I promise I won't shoot outdoors anymore once the range is complete, and it will be complete by Thanksgiving or whatever. You know, that's one thing I would do or could do. Am I worried about the security of whatever things I have in my barn? I don't think I would put up airport lights on my barn and destroy the tranquility of a neighborhood that's rural. I would maybe put motion detector lights up there if I'm worried about somebody, so that they're not on 24/7, but they come on if there is some threat or a deer walks through or whatever, but at least they come on and they go off. What else would I do? I'd probably put a security camera up and have it be monitored so that if somebody shows up and they aren't deterred by the fact that some light flashes on, then security folks can alert law enforcement who can come out. And maybe they'll apprehend the person who's ripping off my barn. But I wouldn't have lights and music going on all the time, totally destroying the character of what is a rural area for people who live there. I would be much more neighborly about that. So I can think of lots of things that you could do as a way of resolving this matter without forcing Mr. McCullough to sue you for a nuisance and hopefully, in his mind, get damages and get an injunction against all the different things you're doing. So I'm going to give Ms. Goldman and Mr. Drury a chance to tell me whether you want more time to maybe have conversations, understanding this is how I'm looking at this case. Ms. Goldman, you're the petitioner's attorney. Your thoughts on that, not on any other facts, just on whether you think there's actually an opportunity here to resolve this matter.
Yeah, good morning, Your Honor. Thank you. It's my understanding that the filings from Friday are now available on the docket, and those, Your Honor, are not cumulative. They actually provide the court with the emails and letters back and forth about this issue, these issues that have been going on for over a year and a half.
Okay, that's right. Yeah, no, I don't want you arguing your case. I want you to tell me, would you like to have some conversations with Mr. Drury in the attempt to try to resolve this matter? I'm not sure, even if you give me more evidence that the timing is so consistent with Mr. Anderson being mad that Mr. McCullough filed the initial complaint, that there's no other way for me to assess it other than it was intentionally done. Even if I, understand that maybe that's what the emails are going to point to. Even if I say to you, well, I'm not sure that still that brings it under the anti-harassment statute. I would hope that you would say, no, okay, I'll sit down with Mr. Drury and we'll see if we can hammer something out. But are you saying that or not saying that?
Well, my instructions for my client, Your Honor, are to proceed with this protection order hearing. We've been waiting for months at this point, and we'd like to put on our evidence. We'd like to make our argument. I appreciate the context the court has provided, but I would respectfully disagree with the court that this is not the proper mechanism or not a proper mechanism. And I think the evidence that will be presented and has been presented is abundant. At this point, Your Honor, there's no hope in my view, and that's what the records submitted show.
Mr. Drury, do you have the same position?
Well, I disagree with that assessment, but, you know, I'm always willing to speak with counsel.
But just tell me, is Mr. Anderson willing to make significant changes along the lines that I've suggested here? Because what he has out there is, I mean, if I were neighbors, I wouldn't give up on it. Because that's just, yeah. I mean, it's like they live in a downtown block.
Yeah, I think he would be willing to make changes.
Yeah, I mean, significant along the lines that I've suggested.
Your Honor, may I have an opportunity to consult with my client briefly offline?
Yes, you may. And I'm going to ask Mr. Anderson and Mr. Drury to step back, and I'm going to call the other case, and then we'll get back to you all. And I understand Mr. McCullough needs to be done before the end of the morning.
Okay, thank you, Your Honor.
Yes. Mr. Anderson, Mr. Drury, come on back up. Table's yours. Have seats. Ms. Goldman, you and Mr. McCullough spoke.
Yes, Your Honor. Thank you for giving us the opportunity to do so. Given the comments that you made to the respondent and with the hopes that they landed, my client is willing to see if a meaningful, real, and lasting change can be arrived at outside of court. And so we would propose to keep the temporary orders in place. And frankly, Your Honor, that I think is a condition of my client wishing to allow for this, and to continue the hearing till November 17th to see if a meaningful settlement can be procured from the respondent.
Thank you. Mr. Drury.
Yeah, we're happy to work with him.
Okay. All right. I appreciate, first of all, Mr. McCullough and Mr. Anderson being willing to talk about this. You know, and we just had another neighbor case, and you know, that's a really hard situation. I know Mr. Anderson doesn't live on the property, but regardless, he owns the property, and it's, you know, none of us want to be in a situation where we have this perpetual state of anxiety at the location where we live. That's just not a good human condition. So I will appeal to the good nature of both parties to understand that that's not how nobody wants to live that way. So I really hope you make a good effort here to try to make some peace and figure out how to both properly and responsibly enjoy your own properties. So I appreciate your attempts to do that. Just a thank you from me. All right. I'll reissue the matter for 17th of November work for you, Mr. Drury. Sorry, 17th of November works as the date for you.
I actually left my cell phone in the car, but let's go with that. And if I have issues, I'll definitely get a hold of counsel.
Okay. All right. In the meantime, the protections that I had previously ordered on behalf of the McCulloughs still remain, and we'll set a new date for the 17th of November. And same courtroom, same time, same Zoom information for Ms. Goldman and Mr. McCullough. And Mr. McCullough, if you need to depart, that's fine. I'm signing the reissuance of the order. Ms. Goldman can assist you in getting a copy of that if you wish.
Thank you, Your Honor.
Thank you, Your Honor.
We'll see the parties on the 17th of November. Okay, thank you.
Good day.
Ray Alger, Kevin Nielsen. Will you stand, please, and raise your right hands? The lawyers don't have to stand. I swear the testimony in this case to be the truth, whole truth, and nothing but the truth. You may be seated. It was unclear to me in reading the materials in this case. First of all, good morning, Mr. Hill, Mr. Baum.
Morning.
It was unclear to me whether I do see that law enforcement had been called. I don't know if there's any investigation for indecent exposure regarding Mr. Nielsen. Anybody aware of anything?
I don't believe it's been charged, but I believe it's under consideration for.
So you think it's at the prosecutor's office?
I believe so.
Okay, Mr. Baum.
I think that's probably fair.
Okay. Okay, so let me then ask this. Obviously, Mr. Nielsen has been put under oath, as Mr. Alger. And if Mr. Nielsen's running the risk of a potential criminal charge, obviously anything he says today could be used against him in the prosecution of any case that may be filed. So are you expecting Mr. Nielsen to testify today or not to testify?
It would be brief because he already filed declaration with the court. And obviously we're not going to get into indecent exposure allegation. So I probably recommend that he take the fifth on that issue just to avoid any complications.
All right.
Well, I don't know if I'm thinking along with the court here or unnecessarily complicated things here, but obviously we would intend to ask him about the indecent exposure and a exercise of the Fifth Amendment in a civil case can be construed against him. I would contend that repeated incidents of indecent exposure constitute unlawful harassment.
Yeah, and I don't know that do you have statements of your party or your client that they've indicated this is what's happened? So you can certainly make the case that way. Whether Mr. Nielsen denies it or accepts it doesn't really change what they're telling me, which is, yeah, we've seen it on the camera. But yeah, that the issue doesn't go away because Mr. Nielsen isn't going to testify about it. So I understand that. All right. So I could do mutual orders, and I don't normally do this, although I do it in the first case I had, but they didn't take that offer. I'll raise it with counsel. You know, I have somewhat the same argument back and forth, with the exception of the complaint by Mr. Alger that Mr. Nielsen has indecently exposed himself on the security footage that he has. That's the one primary difference of the action between the parties, but they both seem to yell at each other a lot and complain about what's going on. So I can issue mutual orders, which will tell Mr. Nielsen keep his clothes on and have them, just have no contact with each other.
You okay?
Yeah.
So if otherwise, we can have the full hearing. Mr. Hill, your thoughts?
Well, just because I've had clients run into situations where agreeing to a seemingly innocuous order results in them being stopped at the airport and so forth. I'm hesitant to go in that direction.
Okay, and Mr. Baum?
Whenever you got neighbors that are kind of come to this level of animosity, I tend to think that a mutual order is more appropriate. Because in my experience, when you have a one-sided order in a situation like this, it's used more as a weapon than as a protective device.
Okay. The fact that the parties aren't agreeing to a mutual order doesn't mean we won't end up with a mutual order. So I just want to be clear about that. So if we want to go forward with the hearing, I have read what has been filed, and Mr. Hill, if you want to ask your client to put on the record the general basis of his requests.
Sure. You're Jody Alger? Yes. Can you tell me how long your conflict with Mr. Nielsen's been going on?
Just shy of 2 years.
And how did it start?
Well, it started with me and him. It started at 3 a.m. one morning. Actually started a couple weeks before that. He kept waking me up, and he was outside at 3 o'clock in the morning, banging on water in his garage and making noises and stuff, knowing full well that I'm sleeping right there in my travel room. Went out and confronted him about it. He didn't really say much. Next morning, he came to me and told me that he was going to do what he wanted on his property, and if I didn't like it, I better get used to it because it was going to get worse.
And did it get worse?
Oh yeah, it got worse.
And how did it get worse?
Oh, just the intimidating, the staring, the banging.
Well, give me examples of what that felt like in the moment. What's the intimidating? You're using that term, but what was he doing?
If we're outside and he's in his house, he'll come out as soon as he hears us and just stare at us. Or
From what distance?
probably 50 feet. We'll water his grass and laugh at us. It was calling us profanities and stuff, which, you know,
Did that stop?
profanities for the most part. Yeah. But the watering and staring at us and banging on stuff all hours of the night.
All hours of night means what?
Just any given time at night.
Would do what?
You just bang on his shopper, his garbage cans, stand close to where my residence is, blow his nose repeatedly, shine his lights. He's got these yard lights that he's spotlighting the windows.
Any of these actions that you're describing seem to have any legitimate purpose? Was it explainable?
The lights, he says he's just trying to light up his garbage cans, but his garbage cans are not in my house. The banging, I don't know what's going through his head. He smokes. I don't know if I can bring that up or not, but he smokes a lot of pot. So the more he smokes, the worse he gets.
And has this been continuous over time over the last couple of years?
And it even was this morning, 4:30 this morning. He's out there banging on his garbage cans, blowing his nose, hawking up boogies, stuff like that.
That you can hear from your house?
Yes, it's right there, right next to my.
So since the anti-harassment case was filed, has he engaged in behavior that was annoying or disturbing to you?
Yes, it's the same stuff.
What specifically since the order or since the case was filed?
Well,
has he
he's
done?
started walking in front of my house, videotaping my house at night, like 8 o'clock at night for no reason. He's never walked in front of my house before. He's building these blinds on his property, which he can do. You know, I don't have any problem. I don't care what he does on his property, but he hides behind them. Stares at us while we're out. You know, if we're out relieving the dogs, he's out there staring at us, and so we move away.
So you've read what he's saying about you, that you and your family engage in intimidating actions against him.
What specific intimidating have we done?
Well, that's what I'm asking you. Have you done
That's what I would like to know.
Have you gone out into your yard for the purpose of confronting him at any time? And so why do you have a camera up in your backyard?
Because we have altercated, yelling at each other. And I just figured that he was gonna start getting physical. So I put cameras up on my trailer,
And where are the cameras pointed?
at my trailer,
And for what purpose?
to keep him honest.
What does that mean?
I'm afraid he was gonna damage my property.
Had he threatened to damage the property specifically?
Not that I can recall.
Has he engaged in any use of his property that is that limits your enjoyment of the property, your property? Have you reviewed photographs or still photos or footage from the trail cameras you have up?
Yep.
And you've submitted some of those photographs, or it's hard to see. Are they discuss the indecent exposure? What is indecent? What has he done that would you regard as indecent exposure that you found disturbing?
Just the fact that he's exposing himself in a really rude manner. Putting the camera off, coming back to the camera after he realized the camera was there. He came back 3 to 4 times, exposing himself. Then fully nude. Then it's just the next morning, Scott was at the truck getting ready to go to work. He came down with no pants on, slapping his butt. Then he came back and exposed himself to Scott. And there's a video or audio of him asking Scott if he wants it.
If he wants what?
His whatever he was showing Scott. Exposure. It's all on audio and video.
And has there been any incidents of indecent exposure since the case was filed?
No.
Has he come out in any kind of state of partial undress since the?
Just recently he started coming out in his bathrobe, scratching himself, staring at us.
And you and your family been annoyed or disturbed by this?
Yes.
Has it caused some emotional distress for you?
Yes. I'm actually losing sleep
Have
because I
you,
just don't know when he's gonna.
have you made it clear to him you want him to stop this behavior?
Yes.
And have you called law enforcement?
Yes.
That's all I have for this witness.
Mr. Baum, do you have any questions for Mr. Alger?
I do. So, Mr. Alger, you're indicating that you don't want my client to water the grass at the time he's watering the grass. And you find that,
No, he can water the grass.
so, but you're saying that you find that harassing towards you to water? at that
Blasting
time?
the metal building, yes. In the garbage cans, yes.
Okay,
At 3 o'clock in the morning.
so, and are they metal garbage cans?
No, they're plastic.
Okay, so it's plastic sound?
Yes.
Okay. And you don't want him to be able to blow his nose in his backyard?
Out under my bedroom window.
Okay. Now, you live in a travel trailer, correct?
Yep.
Okay, and that travel trailer is right up on the property line of my client's property. Do you agree with that?
5 feet,
Okay.
5 feet off the
Have you
property.
thought about moving that travel trailer away from the property line so that you may not be as close to him using his property?
No.
Okay,
That trailer has been there. There was a trailer there before this one, and it's been there for a long time. There was never any issues before.
okay, so, and how long has it been there?
This one, probably a year and a half,
And what about before? You had one
a
before?
few years,
No problems before?
quite a few years. Yeah, not a problem.
Okay. But now you guys, seems like you guys are upset with each other. You and, you're not?
I'm not doing anything to upset him.
Okay, well, you called the police several times.
Yeah, because he's harassing me.
Okay. And it looks like you're making
Why is he-
arguments related to throwing yard waste.
Yeah.
Police didn't take any
You
action.
know what? I don't care if he was throwing a yard waste over my fence. It's the snickering and laughing at us and staring at us while he's doing it. It's like, say something, say something.
Okay, so you're upset about that.
Anybody would be.
Okay. And you would agree that you guys have gotten into verbal arguments with my client, correct?
Yep.
Okay, yelling back and forth?
Yep.
Okay, swearing back and forth? Okay. And what kinds of things are you saying towards him?
Just cussing, yelling, calling names.
Okay. And he's doing it to you?
Yep.
Because you guys just aren't getting along.
Right.
Okay. Now you, I think he got concerned about you potentially causing a fire for, you guys were cutting up some rubber?
Yep.
Okay. When was that?
That was in August.
Okay. And I think he made contact with the fire department about that. All right. And they
Fire
came out to
department.
talk to you guys, didn't they?
Nope. Just drove by.
Okay. Did you ever engage with them to talk to them about what was going on? Okay. Did that upset you?
We called the cops on him though.
You called on the cops
Dave.
because, hold on, you called the cops because he called the fire department?
No, I don't remember why we called the cops on that police report. There's been multiple, so I'm,
Was that, what you guys filed the other day
that wasn't,
where,
oh, that was the 911 call. Cause he was getting really, verbal and aggressive
mhm,
about the fire.
mhm. What did you say in response to that when he was upset about the potential
My
fire?
brother
hazard?
talked to him, told him to mind his own business, shut up, it's all on video, and the police report states that we were in no danger
Okay,
to any property or anything.
so you called the police on him because he got upset about the potential,
Because I thought
what he thought was a potential fire issue.
No, because he was getting verbal and aggressive.
Okay, but your brother was getting
Telling us-
verbal and aggressive
no.
as well, right?
Yeah.
What did your brother say?
You have to ask him.
Were you there?
Yep.
What did you hear?
I was calling the cops during that altercation.
Okay, so you didn't hear what was said?
I watched the video.
Okay. Well,
He
what
was,
did
he
your
was
brother say?
telling Kevin to stop arguing or stop yelling, stop mind his own business,
Mhm. Did he swear at him?
probably.
Okay. Was he yelling at him?
Yeah.
Okay.
Because
Okay.
he talks over you, so you have to yell so you can be heard.
Okay. Now, let's talk about these game cameras. You've got, how many game cameras in the back here?
2.
Okay. And
Three.
you would agree one of them was facing directly at my client's house.
Yeah, and you saw it
I did.
was inoperative.
Okay. Well, the batteries have been,
There was no card in it.
okay. Well, I didn't go over and examine it, but
Yes, you did. You looked right at it. You opened it right in front of your face.
I did not touch it.
No, you looked at it.
And then the other camera was over kind of kitty corner by the trailer by my client's garbage cans.
Yep.
Okay. Did you tell my client that you were going to put surveillance cameras up that would surveil his property?
Nope.
Okay. So he didn't know
Hmm.
when that you were going to be capturing images of him because you didn't tell him, right? No further questions, Your Honor.
Mr. Hill, any further for Mr. Alger?
When counsel asks you to agree with his statement that two of you are not getting along, you said, yes, that's correct. Why are you not getting along?
Because she's the aggressor.
When he, in the photographs that you reviewed from the cameras, in which Mr. Nielsen is exposing his genitalia or appearing naked on camera, does he appear to be performing for the camera?
Yes.
In what way?
Just going like this and kind of embarrassing to show you, but just whipping his genitals out. And for the record, we did tell Leslie that we were putting cameras up.
Okay. Leslie is,
Right?
okay. And over what period of time have the gestures, the indecent gestures occurred on camera?
That was on the 3rd of or September 3rd. Yeah.
That was one of the things that prompted you to finally come to court.
Yeah, that was the last straw.
That's all the questions I have.
Any further based on that?
So the The images, that's just from one day.
It was the night of the 3rd, and then the morning, well, those images.
That
were
one
the
night,
of the 3rd, yeah.
That one night?
Yeah.
Okay. And you weren't out there personally to witness?
Yes. Oh, sorry. Yeah, I did. Yeah, I was sitting on the steps of my camper and Scott was standing.
For what time?
Was probably around 8:30. This all went on probably till just after almost 11.
At night?
Yeah. He was that corner of that property is right there, and he was standing in the dark. There was no lights there at that time.
Did you make your presence known?
He knew we were there.
Did you make your presence
Yes.
known? What did you do? Did you talk to him?
Me and Scott were talking, and we were both confronted him about standing in the dark.
So it was dark out. Okay.
We could see
No
his.
further questions.
Mr. Hill, do you have any further testimony?
Well, I'd like to call Mr. Nielsen.
No. Just right where you are.
Mr. Nielsen, you were waving your genitals at the camera. That was posted on,
Okay.
Right.
Yes. Well, Mr. Baum is trying to protect Mr. Nielsen's.
Yeah, so I'm just going to assert his Fifth Amendment right to any questions related to the indecent exposure situation.
With the questioning.
So I'd,
I'm sorry, how are you approaching that? So
We're going to note that Mr. Nielsen is indicating his Fifth Amendment rights, not to incriminate himself regarding the exposure incident. You can question him about other incidents. There's a standing Fifth Amendment objection.
and so may I just put it on the record then that his response to the question, has he on multiple occasions exposed himself to the camera with the intention of annoying my client, that his answer will be that he is going to refuse to answer on the grounds of the Fifth Amendment. If that's on the record and that's understood, then I'm okay with just ceasing the question.
is what it is. So,
Noted. Go ahead, Mr. Hill.
That's all the questions.
Okay. All right. Mr. Baum, do you have any questions for your client?
I do. So, Mr. Nielsen, have you had issues with Mr. Alger and his behavior towards you?
Yes.
Can you describe what you've had?
Very teaming up with brother, and they say I do hide in the dark, and I don't hide in the dark. I'm in the back doing stuff. If you look at my yard is very nice, and I try doing stuff. And anyways, I'm more of afraid of them because they do pack their guns around on their sides. And it's very intimidating when you're packing a 45 around in your yard. And they're intimidating very much.
Well, let me ask you this. Mr. Alger is indicating that you're out watering your grass kind of early in the morning.
Yes.
Is there a reason that you would be getting up in the like early morning hours?
Yes, Your Honor. It was, I worked at a sawmill for 22 years, and my hours were from 4 o'clock in the morning until 2:30 in the afternoon. And so the times that I would get up and water would be that time of the mornings, because by the time I got home, my wife that is sitting behind me is handicapped. So I am taking on all of the burden and trying to get stuff done. And when I do make noises, it's sorry, but hey, I got nostril problem. It's my property. I try to be respectful. You know what I mean? I'm not a butthole. I'm an easy guy to get along with, and they know that.
You guys used to be friends. Is that correct?
Yes, very much. And I want to still be friends, but
And at what point did this start to deteriorate to where you were not friends anymore?
it was just seeing little petty stuff getting called. The cops getting called on me for walking down the road in front of their house on public property with a phone in my hand that doesn't even turn on for videoing, because I am not that kind of guy. I don't carry my phone on 24/7. They assume stuff, so this is what makes it go.
Are you, well, let's come back to kind of the watering the grass. Mr. Alger is indicating that you're out there banging garbage cans. Are you doing that on
Well,
purpose?
no, well, the thing is for one thing, the lights that I have out there, they're only temporary lights. They're on for maybe 2 hours and they're not shining on his freaking trailer. I made sure the other night I hit it by accident, so I moved it. No big deal. I don't care. I have it for the reason for me to go back there because they were complaining about my lights on theirs when they got to put, and for record on this, Mr. Alger did lie about the light. What was that he lied about? It was what was that, babe?
No, pay attention.
I know, I'm just trying to remember.
Well, let me focus you. Let me
okay.
ask you a question.
But
So are you in the back when you're out there watering it kind of in darkness hours,
yeah.
banging on the garbage cans on purpose?
No,
Are you doing that for the purpose of harassment?
no,
Are there times when you get into your garbage cans when you're back there?
yes. And I
Okay.
got garbage, I recycle everything
And Mr. Alger's trailer is right up on the property line?
from here to that wall.
Okay, so is it likely that he's going to hear if you
Guarantee
get
it.
into any of your property back there?
Yes,
Okay,
no matter what.
okay.
yes.
Now, do you
Mm.
intentionally blow your nose for the purpose of harassing Mr. Alger?
I go out and blow my nose all around the yard.
Okay.
No, no.
He complained that you were shining lights on his trailer. Do you shine lights on his trailer
Mm.
on purpose?
No,
Have you shined lights on his trailer?
no.
Is there potential that collaterally, if you have a light, that it might shine some light
Well,
temporarily?
yeah.
Let me answer the question.
Okay.
Temporarily
Mhm.
onto his trailer.
Yes. Yes.
All right. Now, have you had run-ins with him recently? With Algiers?
Yeah, just
Okay. What
not-
happened recently?
I was in the back. In fact, I was placing my light on the corner on my property. And just like always, they come around the corner, both of them. Where there's one, there's two all the time. And they're intimidating. And they sat there and cussed me up and down, one side, down the other. And I just looked at them and they were like, what are you just shining the light on? And I just left the light and I walked away. I don't want nothing to do with it. I don't want any argument. I'm done with it.
Was there a point where you put a white flag near the fence or on the fence?
Yes.
Why
yes.
did you do that?
I wanted peace, and that's what I asked him was peace. And Scott picked a flag up and said, "Look, you threw it down and said, no peace." And I was like, okay, fine.
And that has been since our last court hearing?
Yes.
Okay. On the last court day, did you see one of the Algers videotaping you in the morning?
Mhm.
Explain that to the court.
They have their phones on them all the time. No matter where they go, they got their phones on them. And they videotape me no matter what
And
what
where-
I'm doing. And I don't know when I'm doing it because the camera that's on the corner behind my shop is actually shining on my property to his trailer. My property goes in the back and then his camera's there and it's shining diagonal to his trailer.
Now, the last court hearing we had, and I think you threw out a declaration on this issue
Mhm.
related to one of the Algers videotaping you in the morning.
Mhm.
Where were you?
I was in the back.
Was it in the back or was it in the front by the driveway?
Maybe it was in the driveway.
Do you remember?
Vaguely, because there are so many times that they videotape me. Every time I go around, it's like,
Do you feel that they're videotaping you for harassment purposes?
oh yeah, definitely.
Okay. Are you trying to mind your own business?
Trying to.
Okay. But have they made it clear that they're going to continue to videotape you?
Well, yeah, because they're already doing it when I'm walking by on public property on the street. They're videotaping me.
The yelling and swearing that they do towards you, do you feel that that's for the purpose of harassment?
Yeah,
Do you feel harassed?
yeah. Especially by two of them. And that just got me. And I'm not gonna stand up and do anything, physically, but I just want it over. That's all I want.
All right, no further questions.
Mr. Hill, any further questions?
So, did you decide you wanted peace and then start making gestures to the camera? Or was that?
That was it.
Objection. That I think relates to my standing objection on the Fifth Amendment.
Well,
At least the,
okay, how about asking reference to the date? Was it making the peace prior to September 3rd or after
When did
September?
you decide you wanted peace?
I wanted a long time ago. They know it. I mean, we fight and argue. It's like family. We've lived there forever, mom and dad, same thing, It's like, I'm not out there to have enemies. I'm not an enemy kind of guy.
But you want peace, but you're out there at 3 o'clock in the morning, watering the grass,
That's
being
my,
naked.
no, I'm not watering my grass naked. I'm watering my grass.
Your Honor, I'm going to object related to, I think what I'll call baiting him into talking about the Fifth Amendment issue.
I withdraw that part of the question. So you decide you wanted peace all along, but you didn't change the 3 o'clock, 4 o'clock in the morning, yard maintenance, hose watering and so forth, knowing that Mr. Alger was sleeping, as you described it, about 10 feet from where you were engaged in this activity at 3 o'clock in the morning.
He shouldn't be there. He shouldn't be in the travel trailer that close to the property. I don't know.
So you're
This
mad
is-
about that.
No, I'm not mad about that because it's always been there. Their trailer's been there. What I'm upset is, why can't I go out on my property at my time? Because that's the time I'm used to, just like anybody else. Let me finish. I get up 22 years. These guys have never worked in their life, except for when? Yeah.
Okay, no.
We're getting far.
But, okay,
I'm sorry.
but anyways, it's one of them things. That's my hours. Sorry. I can't change them. I'm up, I go out and I start stuff. And I try to be quiet. If I slip, I'm not doing it on purpose, okay? Because my wife is freaking handicapped and she is the one I'm concerned about. She is handicapped. These guys are out there with their guns walking around. She is afraid of them too. This is what I'm sticking up for, is my wife. dude.
How you're sticking up for it by going out and
No.
watering your lawn at 3 o'clock in the morning?
You know what? I like to have a nice lawn. You go look at my lawn, okay?
Let's just get clear. Can I
Okay, sure.
just, let me see if I understand you correctly.
Sure.
You believe that you are entitled to use your property in any way you see fit at any time of the day because it's your property. Neighbors
No.
be damned,
No,
correct?
nope, not even close.
No further questions.
Not even
All right,
close.
thank you. Any other testimony?
Just a follow-up on that. When you're out there watering your grass, your yard's decent size, is that correct?
Yeah,
And only a small part of it is next to Mr. Alger's trailer, is that correct?
Object to this. I realize rules of evidence are relaxed here, but counsel's testifying.
Well, actually, I'm leading because it was cross-examination, because he called my client as a witness.
Okay, we don't have a jury. Go ahead, just ask the question and
Thank
get
you.
your answer.
So is it fair that you'd say that your yard is actually pretty large?
yeah,
Yes or no?
yes,
Okay. And the section next to Mr. Alger's trailer is actually pretty small. Is that yes or no?
yes,
And is that next to, I think, a shed that you have?
yes,
Okay. And kind of by that shed on the trailer side are garbage cans
yes,
and some other items that you own.
yes.
Okay. And is it fair to say that when you're out there watering, you're not spending most of the time by Mr. Alger's trailer?
No.
Okay. And that's only an infrequent instance.
Exactly.
Okay. But Mr. Alger is getting very upset, even if you come over there at any point. Is that fair?
That's right.
No further questions.
Right. So my ability to regulate peeing in the backyard or blowing a nose in the backyard, or what hours people access their properties, I'm thinking, how could I do that that would be enforceable? It becomes quite problematic, of course, as council might imagine. Whatever the beef is here, it's spilled over into all kinds of ways that you are perceiving each other and antagonizing one another. And we have the issue of the alleged indecent exposure. We'll let the prosecutor's office decide whether there's something there. On the rest of it, I'm going to end up where we started. Commissioner Wall chose, after listening to Mr. Alger, not to enter a protection order. I'm not going to enter a protection order here. What I'm going to make clear, however, is Mr. Nielsen, you heard my prior conversations with Mr. Anderson about being a good neighbor. Your actions are clearly impacting Mr. Alger. That's why he's before the court. That's why he hired counsel. If I were you, I would try to be a good neighbor. Go to the other side of your property and do whatever you need to do. Respect that, during the morning hours, somebody's trying to sleep. And for both of you, you both have made very clear you don't want to speak to the other. So you should honor that. To the extent that one of you doesn't, after we've had this whole hearing and we've had this conversation, it would be clear to me that the purpose of contacting the other party over their strenuous objection, you both have made that very clear, the purpose of contacting the other party would be for the purpose of harassment. So to the extent that Mr. Alger says something to Mr. Nielsen after Mr. Nielsen says he harasses me all the time, then it would probably then enter into that mode. Likewise, Mr. Nielsen, if you were to say anything to Mr. Alger at this point in time, unless the two of you reach some mutual agreement that you can be friends again, which right now doesn't seem likely, but I'm not going to enter an order. I'm going to deny the request for the order. But I want to keep it very clear that you both have made clear to the other that you don't want contact. Give you each a copy of the order. And once again, Mr. Nielsen, I just would strongly suggest that the actions that are causing consternation to Mr. Alger, you have some ability to control that, and you ought to engage in some other way of taking care of your nocturnal duties. Thank you, Mr. Baum, Mr. Hill.
Thank you.
Mr. Blatt? Was Mr. Blatt here?
Who's here for court?
Then we may as well.
Thank you.
Yes, Mr. Blatt is here.
Oh, are you Wingtip TMRV?
I don't know what that is.
I don't either, but that's what you're identified for on the Zoom call. A lot of people can put their name in there, so I know who I'm talking to. Yours just says Wingtech TMRV.
This is really the first time I've used Zoom. I'm not familiar with it.
Okay, well, can you activate your camera so I can see you?
I'm trying to. This is a new phone, so I'm not familiar with it. I can't see anything where to activate the camera.
Well, go down in the lower left. There you've changed it. Oh, did you do that? Okay.
To start my video.
So on the lower left screen, you should have a little, there, I think you're going to come on here in a second. Yeah, there you are.
You see me?
Hi there.
Okay, I don't see me, but
I see you. And did you mute it? No. Okay, so I need you to unmute, Mr. Blatt. Click on your microphone. Mr. Blatt, in the lower left corner, there's going to be a little silhouette of a microphone with a line through it. You need to click on that. I can't hear you until you do that. I can't hear you. You've muted your microphone. You need to unmute it.
okay, can you hear me now?
Yes, I'd like to be able to do both, hear you and see you.
Can you see me? Can you hear me?
I cannot hear you. I can hear you, but I cannot see you.
Shit.
I heard that.
Sorry.
There you are.
Okay, can you hear me?
I can. Can you hear me?
Yes.
Perfect. And I can see you, so don't change a thing.
All right, I won't touch it.
So there's a motion on the calendar here. You're representing yourself, correct?
I am myself.
I
I'm in
know.
propria persona.
I'm sorry?
I'm in propria persona.
Okay,
I
well, in
am
any
myself.
case, you don't have an attorney and you'll be running your own defense. Is that what you're telling me?
Yes.
Okay, and so the state's asked to, there's just a state, the city of Tumwater is asking to continue the trial. Did you see that motion?
No, but I'll take your word for it.
Thank you. But I will tell you what the substance of the motion is.
I have to explain if you missed the last hearing. I was poisoned by insecticide. I bought anti-flea spray for my dog and it said non-toxic on it. So I sprayed it all over the house and my bed and my clothes, and it knocked me out for 2 weeks, and I still lose my balance sometimes. It was really poison.
Okay. I'm sorry to hear that. But here's where we're at on the trial. The state filed a motion. Let's see, right now, trial is set for confirmation is October 22nd, in 2 days. And then the trial is set for October 29th and 30th. The state's asking to move that because they have a witness issue. One of the police officer apparently is not available in that time. And so they want to move the trial, maybe a week or two. And I guess I would get your position on that request.
Well, what'll happen if I decline that, if I object to it?
Well, then they're asking, I get to decide whether or not the state has shown good cause to continue the trial or not. And then one of two things can happen, I guess. I can, you're objecting, I can sustain your objection, not continue the trial, and then the state would probably be out of luck. Or I could find good cause because a material witness is unavailable, and then I can go a little bit beyond when speedy trial is to allow the trial to take place with the state's witness. And I can tell you a couple of things. One thing that this is a fairly common occurrence from both the defense and the state. And if a defense comes to me and says, hey, look, I need these witnesses to defend my case, but they're not available, can we move the trial? I'll generally accommodate that. I'll let people put on their defense. But the same is true for the state. If they have a witness, and I think who is material to their case, and they can't proceed without, I'll give the state some leeway to find good cause and reset the trial to when that witness can appear. So that might be a spoiler alert, but it's up to you. You don't have to agree. No one's asking you that. I'm just asking, I'm telling you what the state's asking. I'm telling you what generally happens in situations like this. And I'm just asking for your response, and then I'll make a ruling.
Okay, if you deny the prosecution's request, then the trial would be held in 2 days?
No, the trial, I don't know what would happen if they denied the state's request. Then if the state can't proceed, they can't. But I think
Okay.
I kind of hinted that generally I grant this type of motion, but because I want to be upfront with you. But it's
Yes,
up to you as to how you want to decide.
Well, I object to their motion.
All right. I'm going to find good cause to continue the trial because of the state's unavailability of a state's witness. I'm going to ask Ms. Kidmacher, when's the soonest available date that you can be ready and have a trial? And I'll set it for that date.
Your Honor, my understanding is the officer is unavailable through November 8th. Other than that, I don't have notes as to other unavailable dates.
So what we're going to do then, Mr. Blatt, we're going to set the trial for November 17th and 18th, and then we'll have confirmation on, let me put these on November 12th, which is a Wednesday at the afternoon.
May I ask something?
Yes.
As I understand, the hearing I missed was the motions hearing, right?
No, this is the motion hearing.
Okay, I'm not prepared because, as I said, I was sick and I'm still recovering.
No, but
Can't
the
we-
motion is, hang on just a second. The motion is to continue the trial. And I've already asked you what your response to that is.
Oh, so it's the prosecution's motion, but I also,
Yes.
didn't I also notice a motion hearing?
Okay, we can renote that if you want. What, I didn't see that. That's not
Yes,
what I'm
please.
here for here today. When did
Let's-
you ask for that motion hearing to be held? Oh, I see.
Your Honor, at the hearing back on September 3rd, I see a note for a motion hearing set for today. Defendant must file his motion no later than October 6th and.
Well, that was me. Yeah, did you ever file anything?
I don't think so because, like I said, I
Because you were
was,
sick. I get it. Yeah, all right. Well, you're still free to, let's see. Well, do you want that motion heard?
yes, please, but I'm not.
You better
prepared.
file it. I mean, you were supposed to file something by October 8th. We didn't get
Right.
anything.
Right. Can we reset that and the deadline for me to submit the motions?
Yes, we can do that, but we'll probably, in order to accommodate that, we're gonna have to move this trial out a little bit further.
Okay, past the speedy date?
Yes, it's already past the speedy date based on my finding of good cause because of the state's material witness unavailability. I can, at your request, if you want your motion heard before that, I'll accommodate that, but we're gonna have to mess with the dates a little bit.
Okay, I'll waive speedy trial rights for that.
Well, I don't even think we need to get there. I can make findings. Okay, so let's forget those dates. Let me redo these dates here. Well, let me ask you, how are you feeling now? How quickly can you get your motion together?
I'm doing okay. Like I said, I lose my balance sometimes, but I'm getting better.
I'm just asking you for a time limit. How much time do you need? I'll give you the time you need. I just want to know how much you need.
1 week.
All right.
1 week.
So hang on just today. Let me take a look here.
And Your Honor, I'm not sure what type of motion or whether it's going to be something that requires officer testimony. So I would just ask that it be.
My guess is if it's constitutional grounds, and if you need officer testimony, you can ask to reset it, but I
would ask that it be set after November 8th.
all right. Because the officers need to be
Correct.
present. All right, so we're gonna set a motion hearing for November 10th. All right,
Yes.
you need to have your motion filed by October 27th. It's a week from today, so you have a week to get your motion together. Get it
Okay.
filed by October 27th. The state needs to get their response in by November 3rd. And then the motion will be heard on November 10th. Why don't we just do a confirmation for that date also? And then I already moved the trial date to November 17th and 18th. We'll just leave that date. And then the confirmation will be the same as the motion hearing date on November 10th. And if he's successful, then we'll do it that way.
And you said trial 17th and 18th.
What's that? 17th and 18th. Okay, so do you understand where we're at?
Yes.
When do you need to have your motion filed by?
The 27th, 1 week.
Right. And then the state by the 3rd, we'll see everybody back here on the 10th.
Okay. Thank you.
Hang on just a second. I have another question for you. Have you been getting text reminders of court dates?
Yes.
Great. We'll see you back here, and then this will be excluded from speedy trial calculation. I'll make that finding based on the witness unavailability and to accommodate Mr. Blatt's ability to get his motion in. Understand all that, Mr. Blatt?
Yes.
You're free to
Got
go.
it. Okay, thank you.
Sure.
Let's do people against Owens, Marlon Amir Owens, 25B149007.
Ready, Robert. Sherwood Inspector Marlon Owens, is there a warrant that needs to be recalled here?
It's already been recalled. Where were you?
Oh, out of town for work,
Your name?
Marlon Owens.
Did you bother calling anybody?
Well, I did, but it was the day after, because I called before and shut.
You can't do this. You can't do this. You just can't do this. Why would you not call before? Why would you not have told me when I set the sentencing date for October 16th, Judge, I gotta work? Why would you not have told me before you went out of town, Judge, I've gotta work?
Well, because I asked the clerk before, could I get a Zoom interview, and they wouldn't let me do it.
Mr. Owens, you're not gonna force me to talk about other things, are you? Because here's a fact. I told you to show up, should have been here the 16th. If work made it impossible for you to show up, you should have told us on the date of the sentence date. When I set the sentence date. And if you didn't know then, the moment you found out, you should call and said, I need an adjournment. Don't just walk in here 4 days later. I got to read this report again. I don't remember. I don't think the victim showed up, but they might have. Wait a minute. Oh, yeah, the victim showed up. Oh, yeah, the victim showed up. I remember this one now. If you pull this nonsense with me again, bring a lot of cash with you because I'm going to set a high bond, okay? You had a victim here that showed up. I was here. Ms. Patillo was here. I read the report. She read the report. You're not going to inconvenience people. If you're that rude in real life, that's your problem. You're not doing it in here. Are you with me?
Yes.
This was an ugly one, too. Ugly. Ugly. Let's set another date when it's convenient for Mr. Owens. I have a good mind to forfeit your bond and send you to jail right now. You know that? I have a good mind to take the, I mean, I just do. I have a good mind to set a high bond right now. You play this nonsense with me. I got called out of town for work. I don't get it. You might as well bring in a banner that says, I have no respect for the judicial system. Not for me. Forget me. I'm just a pawn here. I'll sit here as long as they let me, but can't be doing this. Do I have a date? We're going to have to set it for November the 5th at 8:30. John?
Yes, sir.
Mr. Haynes, will you do me a favor? Or somebody, just take this down. We got it. The victim was here last time. Make sure victim notified. Is that convenient with you? I don't want to inconvenience you in any way, Mr. Owens. You sure? Okay, I mean, you don't want to do it on your boat or something next summer?
Judge, look, how you pointed on this.
Yes, Ms. Patillo. And she's still gonna be on.
Will she be here that day or do we?
I assume that's the day that they gave me in. Okay? Thanks a lot. Don't do it again. Good luck.
Did you want me to lock that file down?
One of you guys, who cares? Yeah, it doesn't matter to me. Thanks. All right, Faraz Carter Sharp, Shoe 4G700688.
Nice to have Mr. Sharp. It's good to learn from Kalamazoo this morning.
Mr. Sharp, your name?
Sharp.
I need probation in here, Emily. So this was taken under 7694A. And I sentenced him on April 3 of 25. I gave him 6 months probation, 12 domestic violence program with 12-week follow-up, no contact with Alexis Myers, no firearms, dangerous weapons. I said he was to surrender to the court on the first business day following his release from custody because I believe he went out and picked up another charge. And I have, it looks like I have the following: failure to refrain from violating a law, being convicted of 3 different counts. And this was a guilty plea September 29th. He was convicted on July 3 of 25 with assault with intent to do great bodily harm less than murder, domestic violence, and or assault on a pregnant individual. Second offense, knowingly assaulting or assaulting and battering a pregnant individual and then failing to refrain from having contact, direct or indirect, with Alexis Myers. So when I took those pleas September 29th, I said I wanted to show up in person, and that's where we are. Your name. What was the sentence on that? Can you tell me? Do you know?
Judge, he's serving 3 years probation. Probation is gonna go to his March of 2028. But in the interim, while that case was pending, and I understand it's not for this case, but he was in custody for 86 days until that matter got resolved, which was this year in 2025.
Do we have proof of that? Yep. Can you,
I have the full order of probation from.
can you give it to me, please, or tell me what's in it? Does it in fact indicate that he had 86 days credit coming?
Yes, and he got sentenced July 16th of 25 and 3 months probation. It looks like, his terms included mental health treatment and then a domestic violence or battered intervention program. It says that he must complete cognitive behavioral therapy program, can't change his residence, no contact with the victim, can't have a weapon, maintain employment, 50 hours of community service, it says in lieu of fees. And then it does state on here, he has an 83-day jail credit. And all 3 counts were taken under high.
Well, I just want you to know his status has been revoked on this case. So this conviction, I revoked his status back on 7694A status. Back on March the 20th. Is there anything you want? So I'm going to sentence him anew here. And we'll go from there. Did he do his domestic violence program?
So I actually reached out to them last week as of September.
I'm talking about the domestic violence program with 12-week follow-up
Yeah.
that I ordered.
Okay, so when he was in custody for those 83 days, he lost credit for what he already had.
I don't know what that means.
Like, she made him start the program all over. Because.
How long had he gone before the offense date on July the 3rd?
2 or 3, if I remember.
So here's the problem. So
Yes.
I'm going to sentence you brand new now. Do you understand that?
Yes, sir.
I ordered you back in August of 24 to go to the domestic violence program with 12-week follow-up. At some point, I must have ordered him not to have contact with her, right?
I think we talked about that last time. I put contact and it actually.
That's a violation, no assault of abusive or intimidating behavior. What really troubles me here is maybe, just maybe, if you'd have done the program when I told you to, maybe this new offense wouldn't have occurred. How tall are you?
6'1".
How much do you weigh? How much does Alexis Myers weigh? How tall is she? You think that's a fair fight? I don't either. I don't either. Not that anybody should be fighting. But I'm just having a real hard time. I always have a hard time grasping, particularly when it's really, how do I say this? I don't understand a man putting his hands on a woman at any point. And I sure don't understand a man putting his hands on a woman just unprovoked and doing this type of thing. I always kind of think, geez, maybe you should go pick on the heavyweight champion. You know what I mean? That's my feeling. Or whoever the WWF champion is now, or UCF, or whatever they got going on. So what do? I mean, I could say to myself, well, he served 83 days. I could say that. But I could also say he wouldn't have had to serve 83 days, and maybe he wouldn't have been convicted if he'd have done what I told him to do in the beginning. Give me a first page of the register. Did he pay all his fines?
Yeah, everything's done except for the class. He completed the intake, and as of last week, he had 6 weeks of follow-up, so he has 6 weeks left.
What judge was he in front of in Detroit? Was that in Detroit? Yeah. What judge were you in front of?
Yeah, Virginia Thomas.
I mean, you seem like a respectful kid. Why you've got such an anger thing going on, I don't know. She was pregnant, right?
Yes.
Did you know that? You didn't know? Was it your child? Yes. It was your child, right?
Yeah.
It wasn't your child?
Yeah.
And you didn't know she was pregnant? No?
Sure.
Do we have the victim's phone number?
Probably I don't know if it's up to date, but it's in the police.
Would you go see if you can get a hold of her and ask her to zoom in, please? Just have a seat 1 second. I'll be right back with you. Thank you. Were you back on that other case? Okay, what'd she say?
I called the number in each police report, and they're both disconnected. That's the only phone number I have for her.
All right, recalling Faraz Sharp. 24G 700688. Name again?
Sharp.
Casino.
Is there anything else anybody wants to say?
Judge,
Pardon?
if I may.
Yeah.
Yeah, Judge, given the serious nature of the violation, had Mr. Sharp not served those 83 days, I think likely outcome that he would.
Let's put this damn thing on.
Wait a minute, guys. You gotta, I'm sorry. He's likely out.
Would have just been a jail sentence because he was filed, but he did do those 83 days. He is under a felony probation now, and if he were to go amiss or violate anyway, now he's facing felony consequences. He is engaged in the program. He's got 2 good jobs, so he's early 22, is that right? He's a truck driver, but he also has kind of a specialized job. He's a video game shop. So he's kind of at a crossroads in his life, but he does have an opportunity to get things turned around. There is a penalty, of course, in the violation that this conviction's already been entered. But I would ask the court, with.
I understand your argument.
I would just ask the
I
court
know.
to sentence to a concurrent probation with the county probation is going to be.
Do you have the police report on the felon?
Yes, I actually put it on the blue back. You should have it. I made a copy for you and give you.
Oh. I just want you, you know, and I understand what you're arguing there, and I give you kudos. And I'm certainly not going to disagree with it, what anybody else did. We all have different perspectives. All I know is he's on probation of me. I ordered him to do something. He didn't do it. And then he went out and he was acting like a bully again. Did you get a chance to look at this police report?
I don't. Just a little off of this, or made a reference.
Let me just read this to you. The officer was dispatched to a location. The caller, the victim, was advised she was choked by her ex-boyfriend and was waiting in her car for police arrival. On arrival, dispatch advised Sharp was leaving toward the front of the complex where I just parked. Sharp appeared to be in a hurry and attempted to walk past myself and another officer. I advised he was detained and he was handcuffed to the rear. The other officer searched him for weapons and contraband with negative results. I made contact with Myers and I immediately noticed redness around her neck and an abrasion under her left eye. She advised the following: they have 2 children together and she is currently a few months pregnant. An argument ensued over her car. He wanted to use the car. She said no. He was asked to leave, instead took a shower. Another argument ensued. He hit her with a damp washcloth across her left face and chest. She ran downstairs and threatened to call 911. He met her at the bottom of the steps. Rear neck choked her for approximately 10 seconds until she almost lost consciousness. She was then slammed to the ground. He then let her go and said, "Are you going to listen now?" He then grabbed her by the neck with one hand and choked her against the couch. He let her go and she grabbed her 2 children and called 911 while waiting in the car. She declined medical treatment. She sustained an abrasion under her left eye, abrasion on her right cheekbone, back of her neck was reddish in color, front of her, we have a handprint that was reddish in color. I mean, I'm kind of having a hard time with this. Actually, you know what I did? Now I see what happened.
You entered the.
I entered the conviction, sentenced him on April 3. Okay, thank you. This one was confusing. I entered the conviction on April the 3. And
Now, this one was up on October 3rd, off of the new sentence, so.
we didn't violate him before
Because of that.
because of the fact that there was no conviction, I believe is what happened, correct? Am I right or wrong? This one was so strange.
I think he was in custody around that April date.
He was. And then you sentenced him and he got out, when did you get out? May 2nd.
But he was on probation at the time of the initial assault. And I'm talking about the subsequent assault on the victim with the GBH case, assaulting a pregnant individual.
Yeah, he's got on probation August 6th of 24 here. And then he was convicted. You entered conviction on April, or sentenced on, you entered conviction and sentenced him April 3rd of 25. And the offense date from the Third Circuit case is October 17th of 24.
So I misspoke. I'm gonna sentence him on the probation violation, okay? I can't get over the fact that you Did I let you finish, everybody? Everybody, do you want to say anything? You want to say anything? I'm asking him, I mean. I can't get over the fact that you didn't do the program. And I still think if you'd have done the program, probably this wouldn't have happened. That's why we send you to programs. Programs are to rehabilitate you. They're not to put you through extra work just because we can sit and laugh about it. And you didn't do it. He did not do that before I ordered him to do that back in August of 24.
Well, I had something that I didn't want to add.
Go ahead.
And it looks like there was only, maybe a few weeks, maybe it was a short of 2 months between the sentencing and when that next event happened, the felony attack. It was a relatively short time. And one of the things with these kind of situations, and sometimes the treatment counseling has to do with an anger management issue, but I'm referencing something else I was told, learned along the way, and that's that good. It's not always exactly an anger problem. Someone pointed out to me once, people who do this kind of thing don't often hit their bosses. They have some element.
Don't
hit their bosses. They hit women, but they don't hit their bosses. So it's not exactly uncontrollable anger, that it's more to do with gender relationships, dominance, that control, those kind of issues. And it's a very specialized kind of counseling.
Which I ordered the domestic violence.
Ordered, but this happened
2.5 months.
very close, pretty close time. And these lessons take time to be absorbed. Even had he done it, he may not have been in a place where he had been really rehabilitated by it. What I'm getting to is that at this point, now he's got a felony case. He's got to go through the same kind of retraining. He did deservedly serve jail time a lot of days. You can't excuse what was done. But 83 days isn't nothing either. And ultimately, he's got to go through this training somewhere or some court, and hopefully it'll have the desired impact. But I'd ask the court to hold off on any further sanctions until he completes that, and we can see where he is and see if he does improve from the person he was before.
Let me see something here.
And he is in another program now with Third Circuit, parole officer, they confirm that for me.
I mean, I could extend probation.
And Joe, that's what he's looking for, because he's gonna be on probation for the next almost 3 years anyway.
All right. I'll tell you what. Your lawyer just kept you out of jail, son. I'm not sure I'm doing the right thing here or not, but here's what I'm doing. Give me the small whiteout, please. Probation is extended for a period of 6 months. You're to pay additional costs of 75, additional probation fees of 120, and your probation now will go until pardon? Should be April the 3rd of 26. Defendant to serve 30 days jail commencing on 3/1 is March 1. What day of the week is that, Jennifer? Can you hear me? Jennifer, can you hear me?
Sorry, Judge, my headset keeps disconnecting on me.
Is March 1 a day of the week? Is it a Monday through Friday, I guess is what I'm trying to say.
The 2nd is Monday.
All right, here's what I'm doing. Probation is extended for 6 months. You're to pay additional costs of 75, additional probation fees of 120. You are to complete the domestic violence program, and you are to appear here to serve 30 days commencing on March the 2nd. I will suspend that and make you not do that, or not require you to do that if you're otherwise compliant. You do these things, you comply with probation and the circuit court and everything else. We're gonna give you a jail start date, Jennifer. Make sure that Lisa knows what I'm talking about here.
A jail start date.
Jail start date of March the 2nd at 8:30. He's to appear. Court will consider suspending that if defendant compliant, and you're to complete the domestic violence program. I'm going to give you 2 weeks to pay this. If you have the money today, that's fine. If you don't, you're going to pay on this case by November the 4th. I hope I'm doing the right thing. I mean, I want to be understanding of the fact that he's served 86 days or 83 days, and that, he'd already served 19 on this case. So if they'd have run concurrent, I couldn't give him any more time. But I'm still troubled. I'm really troubled that you did what you did. That's the sentence of the court. You fully understand it. Any questions? Thank you, Mr. Haynes. You saved him. Good luck. Here, do I have Shearer and Rice here?
Your Honor, if I may, I've tried calling that phone number 3 times. It asks you to tell that number who's calling. I tell it that I'm calling from the district court, and it hangs up. So there's no voicemail I can leave. They just do not allow the call to go through.
Ms. Kingsley, are you on this case?
Yes, Judge.
Let me call it and I'll go from there. I want to make sure I understand your argument. First choice, MHLLC versus Marshall Shearer and Robert Rice, 2403493. Your name?
Brianna Kingsley for the plaintiff, Your Honor.
I don't have anybody from the defendant here, but I'm having a hard time with this. You guys are telling me that they paid what the consent judgment required them to, except no interest.
He paid everything minus the accrued interest.
Well, wait a minute. Let's look at the consent judgment together. I mean, this seems pretty harsh. They gave you $56,000, right?
That is correct. 56.16 and 14 cents.
I mean, I don't know where he is, why he's not here, but he entered into a consent judgment with you. And it says, let's read it together. Defendants Marshall Shearer and Robert Rice shall be allowed to continue to retain possession of the 2004 Redmond manufactured home, serial number, etc., which is located at 24315 Kingston Circle, so long as they pay the entire accelerated loan amount, $56,092.04 to plaintiff honor before June 10th. All payments shall be made in certified funds. I'm just going on. If defendant defaults, judgment of possession shall, plaintiff shall have the right to proceed with execution of the judgment immediately, and the court officer shall seize the home and shall remove any personal property. Where does it say anything in here about paying interest on this? I don't see where anything in this judgment says that they had to pay interest. I mean, look, Ms. Kingsley, come on. The guy gave you $56,000, and now they want to complain that he didn't pay the interest, and the consent order for possession was entered on May 22nd, and he in fact paid it by June 10th, and the document doesn't say, and I know you didn't prepare this, by the way, or maybe you did.
This is not.
Well,
I did not file the
come
motion.
on.
However, yes, I am here present to argue the motion on behalf of my client. Yes, correct. My client is merely seeking the additional interest.
Well, they want to.
Either a default or an order directing.
How did they
the
default?
pay.
If the consent judgment doesn't say anything about interest, how did they default? Or alternatively, why are you guys coming back and asking me for payment of interest? I mean, geez. Do you have anything else?
Your
Mr.
Honor,
Pallets. Mr. Pallets should have come on this one.
Your Honor, it sounds like you've already read through the motion and everything. I'm merely here to present my client's position that they're seeking
Yeah, they got to
of the
quit being
interest.
so greedy. They'll lose credibility with me, right? I mean, you don't have to answer that. I don't want you to answer that. That's not fair. I'm just going to deny plaintiff's motion. Plaintiff's motion denied for the reason the consent judgment did not call for payment of interest, right? Tell them to stop being so greedy. I mean it. This is over the top. I read this and I'm thinking, what am I missing? I went back and read it again. And then I said to myself, nothing. I didn't miss one thing here except they're going a little overboard. That's it. Thanks. Can you prepare an order for me? Will you do that even though
Yes, I can do that.
chastising you?
Yes,
You know you're one of my favorites, but still, I got my job to do over here.
Judge, I completely understand. And
Thank you very
merely here on behalf of my client. So
I know, I get it. Take care. Have a good day.
Thank you for the court's indulgence, Your Honor.
You're welcome. We're on the record in BU 2023 CR 413, State of Kansas versus Cheyenne Lee Pamp. Please announce appearances.
Jared Begier on behalf of the state.
Your Honor, Darren Patterson here on behalf of Cheyenne Pamp. This Pamp does appear from the Butler County Jail Facility. Judge, this is a case where there's one count of misdemeanor theft. Pursuant to plea negotiations, Ms. Pamp would enter a plea of guilty to that charge. Or, I'm sorry, a plea of no contest.
Ms. Pamp, is that right? You want to plead no contest to the sole count of misdemeanor theft?
that is correct.
All right. And by pleading no contest, you don't want to admit the charge, but you don't want to deny it and take it to trial either?
Yes.
You understand, even though you're not admitting the charge with a no contest plea, you'll probably be found guilty anyway and unable to appeal that conviction?
Yes.
Is anyone making you enter this no contest plea today by any threats or promises other than your plea agreement?
No.
All right. Mr. Regier, have you a factual basis to support a no contest plea in this matter?
Yes, Your Honor. It would appear that pursuant to the affidavit, there was an encounter involving this defendant in law enforcement on May 17th of 2023. At the time of the encounter, the defendant was found with a bank card issued to one victim and an Emprise bank card issued to another victim, as well as two Kansas driver's licenses and a Cabela's gift card. That's in paragraph 6 of the affidavit. Pursuant to the information on count 1 alleges that on or about the 17th day of May 2023, the defendant did knowingly obtain control over a stolen property or services, to wit, bank cards and 2 driver's licenses, knowing the property or service had been stolen by another with the intent to permanently deprive the owner. Where this case proceeded to trial, the state's evidence would show evidence to that effect, and it would appear that shortly thereafter the encounter, law enforcement communicated with the victim and with a within El Dorado city limits, and it was reported that the items found on the defendant were reported as stolen.
Okay, and I note in paragraph 8 of that referenced affidavit, the victim was a Barbara Gemlick, who did report May 19th, 2023, that a theft of certain items described herein, 2 of which include the driver's license and Emprise Bank card that were recovered by the sheriff's office. So I will find a factual basis exists, finding the defendant guilty. Recommendations for sentencing per plea agreement, Mr. Regier?
Yes, Your Honor. Pursuant to plea negotiations, the state is prepared to recommend a 6 months concurrent with another Butler County case that is 24 CR 537. State's information is that matter proceeded to sentencing approximately 2 weeks prior before Chief Judge Rickey, at which time the court did impose multiple orders on that point. Additionally, the state is not recommending a fine in the current case, that the court determine appropriate costs and attorney fees with appropriate probation fees with 1 year of probation. The state will defer to the court as to whether or not that should be with court services or community corrections. State's information is that this is not a case where there is a request for restitution.
All right, what was that case number? I got all but one number that you said she was convicted and sentenced by Judge Rickey.
24 CR 537 is the state's information, Your Honor.
And was that theft as well, if you know?
One moment, Your Honor.
Okay.
Your Honor, it would appear that an amended information was filed at the court in that case on August 27th of this year. Count 1 appears to allege possession of methamphetamine, a level 5 drug felony. Count 2 appears to refer to a dismissed charge, possession of paraphernalia for use of Class B misdemeanor.
Very well, thank you. All right, anything from the defense concerning sentencing before it's pronounced, Mr. Patterson?
Judge, we'd just ask the court to adopt the recommendations. We'd ask the court to consider that the felony case that is being referenced to is something that happened after this case. It's a 2024 event. This is a 2023. So we'd ask the court to adopt a recommendation for a 6-month sentence concurrent with the felony case, and would ask court that she be placed on corrections, since that is where Judge Rickey has her currently placed also.
All
Thank
right, you're welcome.
And
Ms.
Your
Pam?
Honor, there is
Yes.
one final matter which the state is seeking clarification on.
Go ahead, please.
Your Honor, it would appear that on the record here today, the court has accepted a no contest plea with a factual basis being provided by the state. Upon further review, it would appear that this matter came before the court for pre-trial approximately 1 month prior on September 29th. Based off the state's records, it would appear that the defendant entered a guilty plea at that setting. So the state would be requesting clarification for purposes of the journal entry, which plea is controlling in this matter.
Well, I do see in reviewing my September 29th, 2025 notes, plea negotiations and sentencing recommendations were outlined and accepted by the court. It goes on to say plea and finding of guilty set over for sentencing. So it looks like she has entered 2 different pleas, the first one being a guilty plea. Mr. Patterson, I'm inclined to accept the guilty plea just because it was first in time. But if you want to try to talk me into setting that aside and taking a no contest, I'll listen to your argument.
Judge, 6 of one, half a dozen the other. We just need to get to the guilty and then sentencing.
All right, well, I'm going to set aside what I've done today, since Ms. Pamp, you'd already entered a guilty plea from my notes, and apparently the county attorney's notes on September 29th of 2025. So I'm going to strike the no contest plea finding today and proceed with sentencing on your guilty plea. But I am going to follow the recommendations for this theft. I'm going to order a 6-month sentence and no fine. You will be ordered to 1 year of community correction supervision for 1 year of probation, reporting probation. And you'll be responsible for court costs of $158. Where do you work?
I'm not currently employed.
All right. Why are you not working?
Well, because I don't have an ID currently or any of the documents to be able to get a job, but as soon as I get out, I will be heading to the SAC and then going into inpatient treatment. And so I can hope to get my stuff started there and get, the resources there to be able to get my ID to be able to get a job.
So you're going into the Substance Abuse Center of Kansas when you get out of jail?
Yes, and then I'm meeting up with my corrections officer.
And that's all arranged through your felonies before Chief Judge Rickey?
Yes.
Well, why weren't you working because you didn't have an ID? You're how old?
I'm 23.
What's your highest level of education completed?
I graduated high school.
Have you had any jobs since high school?
No.
So who has supported you the past 5 years? Have you had any legal support in the last 5 years from anyone?
No.
All right. And you just never bothered to get a birth certificate, a social security card? What is it you're lacking?
I'm lacking all of them. They actually had all gotten stolen from me. 2 years ago.
And so now you're accused 2 years later of stealing someone else's ID?
That would be correct.
And you admitted that 9/29. Did you steal them to use them for your own ID, or what was that about?
I had actually just found a wallet in the Walmart parking lot, and I just didn't do I didn't put it up to the counter or tell anybody. I just took it.
Well, I'm going to order that you get a job. Is there any reason why you can't work? Any health reasons or anything?
No.
Then I'm going to order that you get a job, you get your ID legally obtained and get a legal ID and start working, because I'm going to order that you pay the $250 attorney fees. I think you should be able to. You just choose not to work. So I'm going to order that you get a job, that you maintain a job. Those are standard conditions of probation. And then with the funds you receive from that, you pay your costs. As I said, I'm not ordering a fine, but you do need to reimburse the taxpayers the $250 for attorney fees and $158. Your attorney fees are worth a lot more than that, but Mr. Patterson has graciously signed a contract where that's what the county's going to charge you, is $250. And I'll give you 12 months to get that paid, but you can't get off probation until that's paid. You and probation can determine how much per month you're going to pay on that, but you will pay every month on the $158 court costs and the $250 attorney fees. All standard conditions will apply. Should any restitution be discovered, you will be ordered to pay it. You're to have no contact with the woman whose name was mentioned earlier that owned the items that you kept for whatever reason you kept them. And you are to report to your corrections officer as soon as this hearing is over by phone. And the jail should have the community corrections number. Mr. Regier, anything else I need to address?
2 points for purposes of the journal entry, Your Honor. The state, if the court is granting reporting probation with community corrections, the state would request the court determine appropriate probation supervision fee, if any. Also, if the court is ordering that the 6-month sentence in the current case run concurrent with the felony case, the state would request clarification on that as well as leave to journalize the same.
Well, what was the first point? The fee for corrections, whatever their supervision fee is, I don't know that off the top of my head like I do court services. But whatever they charge, if any, she will be responsible for. And then on the issue of whether concurrent or not, since this happened before the other one.
And the state was requesting it run concurrent also, Judge, as part of the plea negotiations.
Ms. Pamp, I don't like that condition. I think that you need to be held separately responsible, but that's what the state agreed to, and I will honor that plea agreement, but I'm not going to tolerate any more problems. You need to get this taken care of and don't come back here on a revocation. You do what you're told to do on both of these. So I will run it concurrent, and yes, you may journalize accordingly, Mr. Regier.
Thank you, Your Honor.
You're welcome. Anything further from anyone on Ms. Pamp's case?
No, Your Honor.
All right, Ms. Pamp is excused. You may go.